Hi, this is our RVD film group consisting of first-year law students. My name is Kerry Jones.
I am Lana Puri.
I'm Naledi Lidwawa. I'm Claudia Gibbert.
And I'm Nicholas Halsey.
The topic we have chosen to do is the law of civil procedure.
We have specifically decided to explain to the general public the action proceedings.
We will also explain the difference between action as well as application procedure.
We hope this short film helps the communities it reaches. From all of us, enjoy.
I will be starting the presentation by explaining the two types of proceedings to you. The first one is the action proceeding, and the second one is the application proceeding. The difference between these two are as follows. With application proceedings, there are no fundamental differences concerning the facts of the case. With the action proceedings, there are fundamental differences concerning the facts of the case. With the application proceeding, the parties to the cases are called applicant versus respondent, and to the action proceedings, the parties are called plaintiff versus defendant. The action procedure is more time-consuming and more expensive than the application procedure. Focusing on action proceedings, there are just a couple of definitions that I would like to clarify to the audience. The first one will be plaintiff. The plaintiff is a person who initiates the case and institutes an action to claim a specific performance. The next definition that I would like to clarify would be defendant. The defendant is the person against whom the action is instituted and who may raise a defense against the action. The next definition is summons. The pleading of the plaintiff is known as the summons. The summons informs the defendant of the plaintiff's claim against him or her.
Is that done? The pleading stage. Notice of intention to defend. The notice of intention to defend is what separates action proceedings from application. If there is a disagreement on the facts of the case, the defendant then sends a notice to the court stating that they will be representing themselves opposing the facts. Plea. The pleading stage is where the defendant replies to the claim of the plaintiff. In this, the defendant may agree to certain facts and dispute others. This plea is then relayed to the plaintiff. Replication. Replication is the stage of civil procedure where the plaintiff replies to the defendant's facts laid out in the plea. It is the last chance for comment on this before it is closed and the case is prepared. Litis contestatio. This is the closing stage of pleading. There is no longer a dispute between the plaintiff and defendant, and the case is then relayed to the court, and a trial date is applied for and set before the plaintiff and defendant appear before the courts.
During the trial stage, both parties have to prove their cases in court, seeing that they differ from each other in terms of the facts. Usually the plaintiff bears the burden of proof and must then start the proceedings in court. Every witness is taken through the following steps. If the plaintiff also wants to give evidence, she will follow the same procedure. Taking the oath. Witnesses have to declare under oath or solemnly declare that they will speak the truth. Secondly, examination in chief. The plaintiff's legal representative questions the witnesses. Thirdly, cross-examination. The witnesses are then cross-examined by the defendant's legal representative to establish their credibility. Thirdly, re-examination. After cross-examination, witnesses are re-examined by the plaintiff's legal representative to eliminate any uncertainties which might have arisen during cross-examination. After the proceedings, the plaintiff's legal representative closes their case.
Defendant's case. If there is no absolution of the instance, then the defendant presents his or her case. This will follow exactly the same steps as the plaintiff's case, namely taking the oath, examination in chief, cross-examination, and re-examination. Thereafter, each legal representative will have a chance to argue his client's case and saying why they think their case should succeed. The court then gives a judgment, along with reasons for the judgment, and the court order ordering the losing party to satisfy the claim, namely to either pay up or to deliver something. If the losing party doesn't comply with the court order, the order must therefore be enforced. This can be done by attaching the assets of the losing party, selling them, and using the money to pay for the winning party. Done.
Now you're probably asking yourself, who can take part in these proceedings? The answer is fairly simple. Every legal subject with the ability to take part can take part. So this ability is actually classified in law as capacities. There are 3 different kinds of capacities with an extra one, of course. The first capacity is legal capacity. This is simply the ability to have rights and duties. Now every legal subject has got those. The second capacity is that to act. This is the ability to perform lawful acts. Children under the age of 7 and persons who are mentally ill have got no capacity to act. Children between the ages of 7 and 18 have got limited capacity to act. This means that their parents will have to represent them. And majors, these are people over the age of 18 who are mentally sane, have got full capacity to act. They can perform all lawful acts. The third capacity is the capacity to take part in legal proceedings. The capacity to appear in court or to be a party to civil proceedings. Children younger than the age of 7 cannot be a party in civil proceedings. They have to be represented by parents or guardians. Minors, which are children aged between 7 and 18, have got to be assisted by their parents and guardians. And majors, of course, can just do it themselves. The third one is accountability. Accountability involves the capacity to be held liable for unlawful acts. Now this also concerns the ability to distinguish between right. The fourth and final one is accountability. Accountability is the capacity to be held liable for unlawful acts. This concerns the ability to distinguish between right and wrong. Persons such as those that are mentally insane cannot distinguish between right and wrong, so they cannot be held accountable for unlawful acts. Children aged between 7 and 14 have a rebuttable presumption for not being able to be held accountable for unlawful acts. Accountability is important in the case of criminal offences as well, but this aspect forms part of criminal law, which is a branch of public law.